Dear distinguished scholars and friends of ASLI, good morning, good afternoon, or good evening. My name is Gen Goto, a professor at the University of Tokyo Graduate Schools for Law and Politics, your host today. It is my great honor and pleasure to welcome you all on behalf of my faculty to the 19th ASLI Annual Conference opening ceremony. First, I'd like to invite Professor Yuji Yamamoto, the Dean of our faculty, to give an opening remark from the conference hall school. So Professor Yamamoto, please.
Dear distinguished scholars from Asia and other parts of the world, on behalf of the University of Tokyo Graduate Schools for Law and Politics, I would like to extend our warmest welcome to you all. Interest in Asia and Asian law has been growing rapidly in Japan as economic and social ties with other Asian jurisdictions strengthen, and our faculty has placed more weight on Asian law in our education and research since 2017. It is our great honor and pleasure to host the 19th ASLI conference, and we are delighted to see that many scholars have gathered with interesting papers on various topics regarding Asian law. This year's general theme is Sustainable Development and Law in Asia. This theme was chosen to reflect our awareness to the many challenges that today's world and Asia are facing, ranging from global warming to uneven distribution of wealth, or from diminishing natural resources to infringement of human rights. Of course, COVID-19 is one of such challenges. The COVID-19 pandemic has been lasting much longer than we expected. While some societies are gradually getting back to normal, we shouldn't forget that many people and societies are still suffering. On this occasion, we would like to express our sincere sympathy to all whose life has been affected by the pandemic. This year's conference marks the third time for ASLI annual conference to be held fully online. As a small attempt to reinvigorate much direct and casual conversation among all the new friends, and which have been definitely one of the essential features of ASLI conference. This year, we have introduced an online networking platform, Spatial Chat. It would be nice if you can give it a try. I hope that the 19th ASLI conference will provide another great occasion to exchange views on various issues and to cultivate mutual understanding and friendship among Asian law scholars. Please enjoy the conference. Thank you.
Thank you, Professor Yamamoto. So let me next invite the chairperson of the ASLI Board of Governors, Professor Sri Krishna Deva Rao of the National Law University, Delhi in India, for his opening remark. So Professor Rao, the floor is yours.
Yeah. Honorable Justice Katsuwa Uga, Professor Yamamoto, Professor Kelry, members of the Board of Governors and friends. Welcome to the 19th Annual Conference of the Asian Law Institute in Tokyo. As Chairman of the ASLI Board of Governors, I would like to extend my warm regards to the University of Tokyo Graduate School of Law and Politics for hosting this annual conference. The theme of this year's conference is Sustainable Development and Law in Asia. Even as we continue to grapple with the COVID pandemic, it's clear that in our imagination of a post-COVID world, we must have a marked focus on sustainability in all areas of life. The pandemic did not just expose the gaps in our health systems, but it highlighted regional disparities as well. It brought to light several challenges facing our world, such as lack of access to education, justice, and resources. insufficient food security, poor standards of safety, unequal and disproportionate climate change impact. In this background, the role of higher education institutions is under particular scrutiny. How we all, as educators, contribute to the development in society in its different dimensions, especially environment, health, rights, dignity, and justice in a post-COVID world. I'm sure that this year's ASLI conference will be able to meaningfully engage with these issues and seek plausible solutions. I would like to thank all those involved in organizing this conference from the University of Tokyo, the National University of Singapore, and the ASLI Secretariat. I look forward to hearing from scholars from all over Asia. Thank you again for sharing your work, scholarship, insights, and ideas with us all. I hope the conference is enjoyable, educational, and one that leads to many more future collaborations. Hope to see you all again in the next year, perhaps in person in 2023 in Singapore. Thank you.
Thank you, Professor Lau, for your nice opening work. So last but not least, I'd like to invite Associate Professor Kelly Loy of National University of Singapore Faculty of Law. Professor Loy currently co-directs ASLI together with Associate Professor Wee Men Sen, also from NUS. So Professor Loy, the floor is yours.
Thank you. Honorable Mr. Justice Katsuya Uga, Professor Yamamoto, Professor Sri Krishna Devarao, honorable members of the Board of Governors of ASLI, and everyone, learned friends and colleagues from all around the world. Greetings and welcome to the 19th ASLI conference hosted by the University of Tokyo Graduate School for Law and Politics. Now, ASLI has grown through the years, including our 16 founding institutions. ASLI now has close to 100 law schools as members. This ASLI annual conference is the premier conference where scholars confer over their research, interact, and develop their work. The objective, of course, is to better understand Asian law in its Asian context and to better develop Asian law in order to help Asian societies face new challenges. As Professor Sri Krishna Devarao has mentioned, the COVID pandemic that has spread over the last 3 years, has taught us valuable lessons. I think one lesson that must be emphasized is that we can only meet global challenges if we cooperate across borders. That, I think, is the one lesson we can all learn from this pandemic. Without cooperation, we can't move forward. Now, this is the third virtual ASLI conference since the COVID pandemic. My colleague and co-director, Dr. Wee Men Sen, and I wish to thank our very kind host, the University of Tokyo, for generously hosting the conference. Now, the team in Tokyo University has worked tirelessly to put this conference together. We must, of course, also thank Ms. Lynette Wong and Ms. Alexandria Chan of the ASLI Secretariat for their tremendous effort in co-organizing this event together with our generous host, the Tokyo University. We also thank the Board of Governors, for their very strong support for ASLI events. Without the support of the Board of Governors, ASLI can't carry on. Finally, we thank all of you from all over the world for supporting ASLI and for sharing your scholarship at the ASLI conference. Again, without your sharing your work here, this conference cannot take place because the conference is for people to meet and to share ideas. All right. So, ladies and gentlemen, I hope you will enjoy the conference. We will all learn new things about sustainable development and law in Asia. This will be a fruitful event where new connections are made, and friendships are being built and developed and sustained. Thank you all. And I hope that we should be able to meet face to face next year at the next ASLI conference in Singapore. Thank you.
Thank you, Professor Lloyd. So now we would like to proceed to the opening act of this year's conference, the keynote speech by His Honorable Justice Katsuya Uga of the Supreme Court of Japan. Before his appointment as an Associate Justice to the Supreme Court in 2019, Justice Uga has taught administrative law for 38 years at our faculty. So today, Justice Uga will deliver his keynote speech by video. His topic is SDGs and the rule of law, a very important issue of today that also resonates with the general theme of this year's conference. So ladies and gentlemen, please welcome Justice Uga.
Hello, everyone. It is a great honor for me to have the opportunity to give the keynote speech at the 19th Annual Conference of the Asian Law Institute. The general theme of this year's annual conference is Sustainable Development and Law in Asia. SDGs address a wide range of issues and end to poverty, quality education, affordable and clean energy, reduce inequality, sustainable cities and communities, climate action, peace, justice, and effective, accountable, and inclusive institutions, to name a few. Hence, these issues relate to various legal fields such as constitutional law, environmental law, energy law, criminal law, family law, social security law, education law, city planning law, and so on. I suppose the areas of expertise of participants in this conference are also extremely diverse. But in my speech, I'd like to focus on SDG 16, which includes as its target providing access to justice for all and building effective, accountable, and inclusive institutions, partly due to time constraint and partly because I'm now in the judicial branch of the government. The 17 SDG goals are all interrelated, but SDG 16 is particularly important because it is the underpinning goal for the achievement of all the other goals. It is a cornerstone to realize the other 16 goals. The rule of law and a transparent and accountable judiciary are essential for respecting fundamental human rights. Therefore, SDG 16 makes promoting the rule of law at national and international levels and ensuring equal access to justice for all as one of its targets. This target addresses democratic governance and civil society participation. Since the judiciary is also part of the government, citizen participation in the judicial process and accountability of the judiciary are important components of SDG 16. Legal scholars in Asia are well positioned to help enforce the target SDG 16.3. The advancement of the rule of law is of particular relevance to the legal profession in academia. Mutual exchange of expertise in this field among legal scholars will be very fruitful. Regarding this point, it is crucial to recognize informal justice systems as well as formal justice systems. In the area of alternative dispute resolution, there are various models in multiple countries, and comparative research in this area, I believe, has a lot to offer. The Task Force on Justice of the Global Multi-Stakeholder Partnership, Pathfinders for Peaceful, Just, and Inclusive Societies, published a report entitled Justice for All. It identified the fact that 2/3 of the world's population lack meaningful access to justice due to indigence or other reasons. Thus, strengthening access to justice remains a vital task to be solved around the globe, including in Asia. In Japan, in 2006, the Japan Legal Support Center was established by the government for the purpose of realizing a society where legal information and services are accessible anywhere in the country. The main pillars of its operations include information services, civil legal aid, support crime victims, and measures for areas with limited legal services, to name a few. I believe other Asian countries have various frameworks to address the issue of equal access to justice, and mutual learning will furnish us food for thought. The COVID-19 pandemic and regulatory measures that followed have thrown many challenges regarding access to justice, and efforts have been made to guarantee access to justice through the use of technology within respective jurisdictions. Comparative research concerning innovative methods adapted in Asian countries will offer insights on diverse methods for strengthening access to justice. The rule of law is a very broad concept that encompasses various fields, but it is obvious that the judiciary plays a pivotal role in achieving the rule of law. Transparent and accountable justice is a prerequisite to public access to justice. In this respect, citizen participation in the judicial process is very meaningful. Citizen participation has been a key concept in the judicial reforms of this century in Japan. Citizen participation in the judicial process allows the opinions to be reflected in the judiciary, which in turn deepens public understanding of the judicial system. This results in a robust democratic foundation of a country operating under the rule of law. One of the main pillars of citizen participation in Japan is the lay judge system that came into operation on May 21st, 2009. It has points in common with the jury system in the US, but is different from it in some respects. Under the Japanese lay judge system, persons eligible to be lay judges are Japanese nationals aged 18 and over, who are selected at random by lottery from among those registered in the list of voters for the members of the House of Representatives. Lay judges take part in the proceedings of criminal trials in the district court, which is the first instance, trying serious cases specified by law, involving crimes punishable by the death penalty or life imprisonment with or without work, or involving offenses that have caused the victim to die by intentional criminal acts. In each criminal case, 6 lay judges are appointed to form a panel together with 3 professional judges. The 9 panel members engage themselves in finding whether the accused is guilty or not and deciding the sentence given to the accused if found guilty by a majority vote. The majority opinion of the lay judges alone cannot form the basis for conviction, which must be supported by at least 1 professional judge. In 2021, 1,005 persons were charged under the lay judge system, accounting for 1.5% of the total number of persons charged in the first instance through ordinary criminal proceedings during the same year, which totaled 66,399. 13 years have passed since the lay judge system started, and so far, the majority of those who served as lay judges expressed the view that it was a satisfactory experience. However, there is also a task. Approximately 2/3 of those who are selected by lottery as candidates to be lay judges decline to be nominated as lay judges. Committees for the increased prosecution is also an important pillar of citizen participation in Japan. There are 165 committees for the increased prosecution across the country. Committees for the increased prosecution belong to the judicial branch. On the other hand, the Public Prosecutor's Office is an affiliated organ of the Ministry of Justice that is a part of the executive branch. Thus, committees for the increased prosecution are independent of the Public Prosecutor's Office. Each committee for the increased prosecution consists of 11 members selected by lottery among Japanese nationals aged 18 and over to have the right to vote for the members of the House of Representatives. In Japan, public prosecutors as a whole have in principle exclusive power to institute prosecution, but there are few exceptions. What is called compulsory prosecution based on the decisions of the committees for the interest prosecution is one of them. The committee's primary duty is to examine whether or not a public prosecutor's exercise of discretion not to institute prosecution of a case is appropriate. If the committee concludes that the case should be prosecuted, the public prosecutor is required to reconsider whether or not to prosecute the suspect. If the public prosecutor renders a disposition not to institute prosecution again, and the committee renders the second decision that the case should be prosecuted, an attorney designated by the court performs the duty of prosecuting the suspect. In Japan, every district court and family court has its own court committee. These committees were first established in 2003 for the purpose of ensuring that the good sense, specialized knowledge, and experience of the citizens would be reflected in the actual operation of the court. Each committee is composed of members selected from among citizens with specialized knowledge and relevant experience, and who play a leading role in various sectors of the community, along with members of the legal profession selected from among judges, public prosecutors, and attorneys. These committee members give their constructive opinions regarding the operation of the court, and through exchanges of opinions with the committee members, the court can keep in touch with the public opinions and takes these opinions into consideration in daily operation of the court. In the area of citizen participation in the judicial process, presumably there are diverse systems, and sharing information among legal scholars in Asia will give us an opportunity to ponder over what we should do to move towards a more accountable judiciary. SDG 16 makes developing effective, accountable, and transparent institutions at all levels as one of its targets. The way to make judicial government accountable and transparent varies from country to country. In Japan, the Chief Justice is appointed by the Emperor following designation by the Cabinet, and other justices appointed by the Cabinet and then attested by the Emperor. The Prime Minister, who appoints other members of the Cabinet, is designated from among the members of the Diet by resolution of the Diet, and the Cabinet, in the exercise of executive power, is collectively responsible to the Diet. Therefore, it could be said that the Supreme Court is indirectly accountable to the Diet, whose members represent all the people. The Diet has no authority to directly confirm the appointment of the Supreme Court justices, but has authority to impeach justices and judges. Also, the appointment of the Supreme Court justices is reviewed by the people at the first general election of the members of the House of Representatives following the appointment, and this will continue to be carried out every 10 years. If the majority of voters favors the dismissal of justice, he or she is automatically dismissed. There are arguments surrounding this system. For example, if the time between the appointment and the first general election of the House of Representatives following the appointment is short, there are no or only a few decisions in which the justice participated, and people have very little information with which to judge whether the justice is suitable for the position. Comparative research on the accountability mechanism of the judiciary may open eyes to new systems. SDG 16 makes ensuring public access to information and protecting fundamental freedoms in accordance with national legislation and international agreements as one of its targets. SDG 16.10. The fourth president of the U.S., James Madison, stated, "People who mean to be their own governors must arm themselves with the power which knowledge gives." This statement eloquently explains the paramount importance of public access to government information as a foundation of democracy. In order to make governments accountable for their actions and enable citizens to make informed decisions on political choices, public access to government information is essential. One of the indicators used to measure progress toward this goal is the number of countries that adopt and implement constitutional, statutory, and/or policy guarantees for public access to information. As of February 2021, laws on access to information have been adopted by 127 countries and territories. However, the quality of this legal system is uneven, and some of them lack the provisions for the effective implementation. Thus, I believe this is one of the areas where legal scholars have an important role to play. Legal scholars should strive to conduct complex research in this area to enhance the understanding of effective legal system for open governments and contribute to the establishment of transparent and accountable governments. Now, I will close my speech by expressing my expectation that at this conference, there will be active exchanges of views on various programs related to SDGs, and that this conference will contribute to deepening of our understanding of SDGs and laws. Thank you very much.
Thank you, Justice Uga, and thank you all for your attention. In the end of his keynote speech, Justice Uga emphasized the importance of the role of us legal scholars in achieving SDGs. So we're looking very much forward to the discussions we will have in this conference. So before closing this opening ceremony, let me make some announcements on housekeeping matters. So after a short break of around 15 minutes, we will move on to the presentation of the session 1. There is only one Zoom meeting room for this whole conference, this meeting, and we will hold multiple panels using breakout rooms. So please choose the breakout room for the panel you wish to join from the button for breakout rooms in your function bar of the Zoom application. The first session starts at 12:45 Japanese Standard Time, so there's no need to rush. If you have any trouble finding out your way, please feel free to ask our assistant in the main room by voice or by chat. There's also some guidance in your e-booklet. Also, as mentioned by Professor Yamamoto, we have also set up a virtual room at Spatial Chat for more casual and direct conversations among you all. The virtual room will be opened after the first session, so please check your e-booklet for the guidance on Spatial Chat. So thank you so much for your attendance once again, and please enjoy the conference. Thank you.